Okay, hello everyone. My name is Buvia Yulin and I'm the director for SCMA. I just want to remind you that this event is in webinar format. That means you can see and hear presenters, but they cannot see or hear you. This webinar is eligible for 1 hour of MCLE credit and 1 hour of MC3 continuing education credit. If you're acquiring MCLE for attending this event, please make sure that the account you use to sign in and the name that is displayed for you during the webinar is a name that matches your state bar. If you did not provide us with your state bar number during registration, please email us at info@scmediation.org. I would now like to introduce you to Mark Lemke.
Thank you, Madam Director. All right, good morning, everyone, and thank you for joining us on this rainy Saturday morning. First off, I wanted to welcome each of you to our first event of the year. The webinar series is something that was launched by Dr. Jack Getz a few years ago, and something that's taking on, obviously, increasing importance in this, our current working from home environment. We're going to be ramping up our programming, and there's an exciting roster of programs that will be announced in the very near future. In addition to increasing the programming that SCMA offers every month, we're also going to be doing quarterly social events to afford each of you an opportunity to mingle, to network, and to meet other mediators at all stages of their career. So more news on that coming soon. With that, let me welcome everyone to our first webinar of the year. Ethical Issues, a Year in Review, and what a year it's been. So it is my distinct privilege and honor to introduce Stephanie Bell-Blondell. Stephanie is a longtime supporter of SCMA. She's a personal friend, but more importantly, she's an associate professor of law and practice and associate director of the Strauss Institute for Dispute Resolution at Pepperdine University School of Law. She also serves as faculty for the Strauss Professional Skills Programs, currently teaching Mediating the Litigated Case, of course, the Women's Negotiation Academy, and she also leads the Conflict Resolution Initiative with the Los Angeles Police Department. Before that, she came from Washington, where she led their dispute resolution initiative, and she earned a BA with honors in American Civilization from Brown University and a JD from the University of Washington School of Law. We are so lucky to have Professor Stephanie Bell-Blondell. Welcome.
Thank you, Mark. And I'm here to introduce Mark, and then I'll tell you a little bit more about our program this morning. And it is my joy to introduce Mark, and I will repeat in saying a colleague and a friend, and a former student who's now teaching, I think, at various law schools as an adjunct. Mark is a highly experienced commercial mediator, super busy during the COVID age. He's now up to 2,500 mediations to date. And I think he brings a really unique combination. When I have him speak to my classes, he talks about a perspective that some of my other guests don't have, which is he was insurance coverage counsel, as well as plaintiff's counsel and defense counsel. So he brings an extra specialty to the table. He specializes in catastrophic injury, personal injury, wrongful death, all facets of employment cases, and various other sundry cases as well. So he's adjunct for Strauss, USC. He has an LLM from Strauss, so I'm proud of that he is Go Waves. JD from USC Law School and a BA from Berkeley. He serves on the EEOC panel, the Central District panel, and Beverly Hills Bar Association as well. Now, Mark is, as you know, your fearless leader of SCMA. He is president, but not only is he president of SCMA, he's co-president this year of the LGBTQ+ LA Bar Association. So thank you, Mark Lemke, for doing this with me. It's much more fun to be too. So let me tell you a little bit about what we're doing today. Last year, many of you may remember about this week, last year, I presented on ethics. Now I'm going to share my screen. That was a very different presentation on ethics. I talked about the psychological processes that would lead a person to be less than they wanted to be, right? It would lead them to, in some way, shape or form, veer from their preferred ethical norms, essentially. So what we're going to talk about today is something a little bit different, which is we're going to actually go into the rules and talk about the rules. One of the things I talked about in terms of a way to keep yourself from doing that process of ethical fading or sliding into less than ideal ethics is to review them. So what we're doing is we're pulling out our ethical code. Each of you received them with the seminar, and you should look at these every year, if not more frequently than that. Pull them out, just put them in your head. Practice the vocabulary, practice application. Now we have a couple scenarios that are application scenarios where we will practice that, but we're also going to kind of take on one of our topics and do that in a more, I'd say, powerful way. I'll call it powerful way. And actually talk about how to incorporate a lot of what's happened in the world in terms of equity into the ethical rules in a way that it maybe currently doesn't exist. So that is the frame for today. And the first thing, I feel like I can't even say this without mentioning, last year on this very day, I was with you all and I got in the car and I drove home and I found out that Kobe Bryant, I think it was the very day, had his plane had crashed, his helicopter had crashed. Or if it was a small plane, his small plane, I can't recall right now. But that sets us at the beginning of Mark taking us into the next slide, which is to talk a little bit about the year in review. I want to ask Mark, am I still showing my notes?
You're perfect.
I'm perfect. Okay, great. So Mark, just remind us so we can get our heads in it. Talk to us about the year in review.
So what a year it's been.
Yeah.
And among the things that we as mediation professionals and among the things that our parties, our attorneys, our clients are all dealing with are all of these myriad stressors, all of the things that cause us, as you mentioned, Professor Blondell, to be perhaps less than we hope to be, ethically and otherwise. So just as a reminder, obviously with COVID, we're dealing with lockdowns, with bankruptcies, historic job losses, eviction issues, working from home. Over the course of the last year, we've had protests for Black Lives Matter, obviously the insurrection at the Capitol, as well as unrest over the election. And then beyond that, we're also dealing with much in the way of the news of sports, as you mentioned, with Kobe Bryant, obviously for those of us here in Greater Los Angeles, the Dodgers World Series, but also the presidential election, 2 impeachments, as well as global wildfires. And we were just talking a few minutes ago about the windstorms affecting Los Angeles, which, I don't know about the rest of you, but I also experienced a power outage as well as an internet going down the night before a mediation, which was one additional stressor, not that we didn't already have enough. All of this is affecting our parties. All of this is affecting our businesses. Much of what it is that I'm going to be adding to this year is some real world examples, some of what it is that I'm seeing in my daily practice on the ground, if you will. So one of the things that I've certainly noticed is that cases are initially with the lockdown, it seemed that it would take effort not to settle cases. It seemed that everybody wanted to settle, just given the tremendous uncertainty with the COVID pandemic. And then a little while after that, I started to notice that it was becoming a little bit harder. And from some discussions with plaintiffs' counsel, one of the things that I've come to realize is that many plaintiffs' firms require courts to be open so that they can get big verdicts. If they can't settle a case through mediation, then they need to rely upon big verdicts to keep their overhead. And in the current environment where courts are closed, how is it that plaintiffs' firms are able to keep their doors open? Well, that puts additional stress on the amounts required from settlements. So cases that previously could have settled for 1x, I'm now finding may be requiring 50% to 250% more to settle, even with the same merits. In addition, lots of defendant parties are running out of money. One of the first mediations that I had, by unfortunate coincidence, after Los Angeles and California implemented the lockdown back in March, was of a small restaurant. And during the course of the mediation, I could tell that something was up with the defendant. And I just kind of checked in with him beyond the merits of the case. And he said that They had had to let go most of the staff, that most of the staff had been with them sometimes for decades, and he'd had to let most of them go that very morning. So that had nothing to do with the case, but that was a tremendous stressor that was facing my party and really impaired his ability to lock in with what it is that we were talking about. Add to that as the day went on, unfortunately, he had received news from the kitchen that because they get most of their business from neighboring office towers, which were closed, they had shut down the restaurant in real time during the course of the mediation. And on that basis, they wound up walking away from the settlement table simply because there was no money to fund settlements any longer. So these are just a few of the things that we are seing. Obviously, we're going to be talking a little bit later on about access to justice, equity, and inclusion, but these are just a few of the things that we're seeing in our daily practices. So with that, Stephanie, let me turn it back over to you.
Thank you, Mark. I appreciate your observations about what's happening at the mediation table for you, and with the context that I've been in, which is trying to settle evictions, many of the same or potential evictions, because there's moratoriums now, but many of the same issues arise. So let's go and look for a second about this mediation, the code. So this is your time to pull out your model code, model standards of conduct for mediators that we sent to you. I'm going to talk a little bit about the source of mediation ethics. Then Mark and I are going to go through the major principles very quickly. This next section should take 10 to 15 minutes tops. We're going to do just a reminder so that you can get your head in it. First of all, mediation ethics are fascinating. When people say ethics or when people teach ethics in mediation or the principles of ethics, I think they often teach them like, there's a lot of shame-based teaching that comes out of law school. So I won't be the first to have noticed that sometimes it's, you can feel like you're getting slapped on the hand if you do something wrong in mediation. And there can be some very orthodox views. And I appreciate that. That helps the professionalism of our field. However, the source of mediation ethics that we're looking at here is kind of merely instructive. We're looking at the model code, which is the best kind of amalgamation of mediation ethics that I think have guiding principles that help us make decisions. Each state, and here, obviously we're in California, you look to statutes and codes for specific principles, and statutes and codes often don't address the full range of mediation ethics. So for example, confidentiality can be covered in detail, but you may not have advancement of the practice covered. So that's why we're looking at this, which is comprehensive. As you know, though, our ethics come from, statutes, codes, rules, but they also come from, someplace like SCMA. SCMA may say, actually, for you to be a member of our organization or MC3, we want you to participate in the advancement of the practice. There's our internal codes as well. We hopefully all have a basement and a ceiling in terms of our ethical actions and where we will go or will we ought not go as mediators. So that's just a reminder of, the source of mediation ethics in general, varied, and that's important. Now, what is this presentation? What is it and what it is not? This last year, we could do an 8-hour presentation on the ethical issues that have come up from ODR. And that involves a specific knowledge of the ODR context and platform that I don't have, and I think many of us don't have yet. So this presentation is not designed to specifically address those really important questions in ODR, like, are the big data providers using our data not attached to our names or our identities in some way? Are they selling that data? What is actually truly security? Who might be able to penetrate a platform? Those types of questions are beyond my pay grade. There are places you can get answers though, and people are beginning to do amazing writing and amazing conversations about that. So also I'm hearing we see from Phyllis that there's an ODR ethics on your website. I love it, Phyllis. So there's another resource right there. So I particularly love this publication that Leah Wing just just published. You can get it on mediate.com as well as other places, and that's a cool thing. Okay, now moving on. What are the model standards? They were originally, I think, 97, and then again in 2005 they were updated, 94, excuse me, and then again in 2005. They're a joint project of the American Bar Association, American Arbitration Association, and Association for Conflict Resolution at the first juncture called SPIDER. And they do not have the enforcement of law. So it's kind of a collected wisdom regarding mediation, ethics, values, and they're rather complete. I think they need a refresh. Okay, we'll talk about that later, but they're rather complete. So the first one, just to remind you, self-determination. Whenever I see self-determination, I kind of think of this concept of, like manifest destiny, the Santa Maria, the Pinta, the Nina, and self-determination of the parties. We think of that as almost a historical term. Hopefully you learned it in history, about the governance, that people want to govern themselves. They want to be in charge of their lives. And I hope it has a resonance for you that's very, what word am I going to use? Sacred. It's very sacred. For me, self-determination of the parties is a sacred concept in my profession. And it's one that is hard to define, I admit, very hard to define, but the rules have done a sort of okay job doing that. So we understand a little bit about what that means. And it should help you decide, what kind of actions you're going to take in a mediation. The principles that tend to, inform self-determination are, do the parties have freedom? Do they have authority in there? Do they have support? Are they given the responsibility to make the decisions? All of those important concepts exist. And so then to what extent do we as mediators exert our persuasion, manipulation, our deception, or coercion? All of those are kind of controversial topics, but self-determination is the thing that holds us back from that. As you look at the rules, hopefully you all are looking at the self-determination rule right now. You can see that there is A is definitional and describes what it is, as well as withdrawal. And B specifically I'm going to read because I think it's important. A mediator shall not undermine party self-determination by any party for reasons such as higher settlement rates, egos, increased fees, or outside pressure from, and then it gives you a list, the media, provider organizations, the court, all those types of things. And so that's where they kind of put in the market dynamic under the self-determination rule. To the extent that you are influenced by the market, that you will make decisions based on getting more cases in a certain way, that they fold into the self-determination rule, which is an interesting little wrinkle there. Okay, impartiality, model standard 2. A mediator shall conduct their mediation in an impartial manner and decline a mediation if you cannot do that. This one, I feel like, is wildly, controversial is the wrong word, but it will make you scratch your head when you actually read the rule and think about how to apply it. And this is one that could probably use a little bit of a refresh. Impartiality, this is from the rule. A, means freedom from favoritism, bias, or prejudice. Interesting. And B1, I want to read to you too. A mediator shall not act with partiality or prejudice based on, and here are the things it's based on, any participant's personal characteristics. Okay, we talk about that a lot. Their background, their values and beliefs. Interesting. Or performance at a mediation. Now, look at the last little clause here, or any other reason. So that is a broad sweep. I think we talk a lot about partiality in terms of, when I first came into the field, I think we talked a lot about it in terms of protected class, ethnicity, national origin. I then saw the field talking more about it in terms of negotiation style. right? Like how you might be influenced by a particular party's negotiation style, because we in mediation really care about negotiations, and that's kind of a hidden bias. And I think this year has brought up a lot of questions about values and beliefs and political systems. But I love this, or any other reason. Fascinating. Okay, conflicts of interest is the third bullet here. And a mediator shall disclose all actual and potential conflicts of interest reasonably known to the mediator. After disclosure, the mediator shall decline to mediate unless all parties choose to retain the mediator, and conflicts rules continue during and after mediation. Again, this is actually a more complete, I think, and clearer rule, and you can take a look at it. Many of the things that I see coming up in terms of disclosure and whether or not you should disclose come under the rubric of this standard. Mark is going to take us to the next three.
Right, thank you, Stephanie. So that then brings us to Model Standard 4, the standard for competence. We'll just read this briefly. A mediator shall mediate only when the mediator has the necessary qualifications to satisfy the party's reasonable expectations of competence. Now, that can mean a number of different things. In the mediation marketplace, is that referring to subject matter expertise? Is that something that's referring specifically to legal expertise? And for those folks who have opted not to attend a law school for 3 years and then taking a bar exam and student loans after that, how does that implicate issues with the unauthorized practice of law? So what are our obligations to address the parties' reasonable expectations? Do we have any obligation to find out what it is that they think that we have in the way of either specific competence, general competence, competences as mediators, subject matter, and then how do we address that? And is there any obligation, for example, to disclose if parties believe that we have a particular competence that perhaps we're not able to bring to the table? That then brings us to the next Model Standard 5 for confidentiality. A mediator shall maintain the reasonable expectations of the parties with regard to confidentiality. Now, this again, this raises a couple of different concepts. So there is a distinction between confidentiality and privilege. Confidentiality refers to information flowing from the mediation process. Privilege refers more specifically to information coming in for subsequent or concurrent legal proceedings. Now, here, as mediators, our primary concern is making sure that information is not leaving the mediation process, and oftentimes settlement agreements will include provisions that will maintain confidentiality. Sometimes they'll even provide for liquidated damages that will provide a penalty, or perhaps we could say an incentive to ensure that the parties are keeping the contents of the mediation as well as the outcome of the settlement confidential from later proceedings. That also creates a tension, though, for certain venues. For example, the California Department of Fair Employment and Housing, mediations that are done under their auspices are not wholly confidential, and sometimes information including what was the amount of the settlement, who were the parties, can be obtained through Freedom of Information Act requests. So how does that implicate the standard for confidentiality that we as mediators are expected to maintain? Next would be Model Standard 6, and that pertains, of course, to the quality of the process. Mediators shall conduct the mediation fairly, diligently, and in a manner consistent with the principle of self-determination that Professor Blondell spoke to ensure the quality of the process. Now, Professor Blondell also spoke to bias. Here, I think that part of the quality of the process comes in as far as the touchstone of neutrality affecting each of us as neutrals. Are we expected to be neutral as to the process that we are providing, the shepherding of the parties towards a settlement, hopefully, or are we expected to be neutral with regard to the outcome? Here, the model standard emphasizes that it's more the process and less the outcome. How is it that that creates tensions within ourselves, particularly given many of the factors that we're dealing with in our day-to-day or that our parties are dealing with in our day-to-day? How is it that we can make sure that we're providing them a quality process, recognizing the difficulties that they're facing before they ever come in the door? I will turn it back, Stephanie, to you for the final model standards.
Good, and let me just say one thing about quality of process. I feel like that one's a little bit of a misnomer. Because when I think of quality of process, I mean, I think of quality control. Did my, weed whacker make it out okay? And did this mediation, make it through? Did they sign the right documents? Think of quality of process almost like your personal integrity, and I think you will do well. I'm not saying that that's what the rule says, but I think it's calling on us to, and the way that they write about it, quality of process is actually a little heightened in terms of the expectations. And often when you're doing ethical scenarios, you'll forget about quality of process and it's the answer. You'll see it's long, right? It's 10 and there's an ABC. There's 1A through 10. So it covers a lot. I think it was the catch-all. So going on to fees and advertising, I'm not going to spend a ton of time on those today because that's not the focus of what we're doing, but they're in there. So you should spend some time looking at them, but I will bring us to the advancement of mediation practice because that's what SCMA is. And that's what your membership in SCMA is. You have a duty to improve the practice of mediation. And by gosh, I have been in this field, I don't know, 25 years or more maybe, and people still don't quite understand who we are and what we do. And professional organizations like SCMA are very much a part of making that happen. There are all sorts of things that you can do. Specifically, diversity is called out in 1A, but I think that as we are moving into a new age of people thinking about how to include fairness and justice and their own mediator persona into these concepts, which seemingly might look like they're mutually exclusive, although I don't think they are, but the neutrality and impartiality, advancement of the mediation practice as a whole is going to be, I think, a really important ethical value that we all have a duty to engage in. I think we have some language to write. I think we have some vision statements to write. I think there's a lot that we need to do as mediators and are called to do right now in the world. So that's an inspiring one to me. So moving on, I want to do one thing before we can move on to our scenarios. You have the ability in chat to post to just the co-hosts, personally to the co-hosts. We've chosen a few things just to kind of get the juices flowing in terms of you applying some of your knowledge to particular scenarios or just getting yourself thinking in the rules. But if you have a great scenario that's come up this past year, whether it's 2020 specific or not, and you can say it in a 1, 2, or 3 sentences, go ahead and shoot that to the co-hosts. And we may be able to incorporate some of the richness from what you've been seeing at the table today. That would be great if we could. So go ahead and do that, and we'll just be looking at that on the side. So again, you can confidentially post to the co-hosts because we want to do it that way. No identifying names or parties or clients in there, of course, but if you have a scenario or a concept, we'd love to see it. So moving on to our first scenario. Mark, do you want to kind of set up this scenario that we've kind of labeled this category of things that both you and I have been seeing as this competition for clients? I think we started out the year with this sense that there was going to be a scarcity of cases, a scarcity for mediators. Now, I've talked to different mediators, and I feel like depending on who they are and what practice area they live in, people are either really pushing forward to settlement or some are holding back. So I think that the mediation field can be impacted in a different way based on this kind of scarcity feel or this competition for client moment that certainly happened before 2020 as well. But set it up for us.
Absolutely. Thank you, Professor Blundell. So this really was a year that I think that we as mediators were realizing some of the challenges that were part of the external environment, whether it was court closures, whether it was bankruptcies, whether it was scarcity. But I think that there was a lot of uncertainty at the beginning of the year that was affecting our profession as well. To what extent are people going to want to mediate? To what extent are people simply going to declare BK? To what extent are people simply going to wait to see when the courts reopen? To what extent are people going to be able financially to hold out until the courts reopen? So this raises or perhaps amplifies the existing competition for clients that we have here in the Southern California marketplace. This is a vibrant area for mediators to practice, but unfortunately, with the sheer number of mediators that are out there, many neutrals find that they are not as busy as they would like to be. Even if you are as busy as you would like to be, there's continuing pressure to make sure that you are always bringing in at least one new case a day for every case that you're mediating, just to maintain. So tremendous pressure. A couple of instances that I came across, one was very early in my career, one was more recently. So very early in my career, I had an adjuster who turned to me during a mediation and said, if you can settle this case for $17,000, then you're our kind of mediator. And obviously, there was a linkage between settling a case for a certain amount of money with the implicit promise of additional business. Implicit, I've seen more explicit than that, and that actually came more recently. I was working with a plaintiff's attorney who emphasized to me that he frequently works with one of the premier mediation panels, that he brings them a volume of business every month, and that quite frankly, they're just not able to keep up with the volume of business that he has. And so he is looking for new mediators to take on his cases. And he turned to me during a mediation and said, blow me away with this one. And I can guarantee that you're going to have a lot of work coming your way. So on that basis, there was a not so implicit linkage between getting a particular result for that particular attorney and his client with the explicit promise of additional business, particularly given that he had said how often he was mediating on a monthly basis and how much more he needed. Stephanie.
Yes, and let's talk through this a little bit, Mark. So in terms of the ethical implications, there may be some that you cite right away. Is there an ethical quandary here, or is this everyday mediation? I have to say, on the one hand, for those of you that are community mediators and those of you that mediate in the commercial market, some of the same actions in different contexts will have a different feel. Why? Because attorneys might be in the room and they're there to protect that advocacy moment. Why? Because money is being exchanged, as opposed to a pro bono environment where money is not being exchanged. So there are some different contexts. So if just listen for that, as we might be talking about one or the other. But is the mediator placed in an ethical quandary here? And how do you respond? So certainly I think we have several up there. Conflict of interest. Is there an obligation to disclose? Confidentiality, quality of the process. I think self-determination is where I want to start though. Could this in some way undermine party self-determination? And you'll remember that I read from you in terms of standard 1B, where, 1B, where under self-determination, where you are not to undermine self-determination for reasons such as higher settlement rates, increased fees, or outside pressures. It doesn't say or future business. But I think that that's kind of inherent in that same concept. But how do you handle it? Mark, how did you handle this first one? You're our kind of mediator.
So the way that I typically will respond whenever somebody is trying to influence me during the course of a mediation with the implicit or explicit promise of future business is to simply say, why don't we focus on settling this one? And then depending upon the outcome, then we can worry about whether or not you want to use me again. And that usually puts that to bed and ends it in as diplomatic of a way as I can, while also kind of shutting down any further attempts at improper influence.
Mm-hmm. Well, I mean, and I think what's interesting here is that there is a rapport building moment where you can joke back, well, I hope I'm your kind of mediator. But there's also a moment in here where you put the responsibility back on the parties, at least in the practice moment, which is, but I'm not the one bringing you the money. Ultimately, they're the ones saying yes, right? So they're the ones that are going to actually bring you the 17,000. I'm not responsible for that. Now, of course, the market wants to make you responsible for this, right? But I think that you can at least, by saying what you said or saying what I said, signal to the person putting the pressure on, that you're either not going to take those types of comments so seriously, but nice try, or signal to them that ultimately the person who's bringing you the money is the person on the other side of the table, and writing the check. So Mark, what else are you thinking?
Really, when we get to duties to disclose, this is one that I find uniquely interesting here in California, as opposed to the way that other states handle this. And for instance, I am part of the AAA mediation panel. AAA, of course, is a national roster, as well as a frequent supporter of SCMA, which we appreciate. But whenever I get a new case from AAA, they require me to make very detailed disclosures that are far beyond what is required of mediators generally here in the state of California. And that is them leveraging their national practice to make sure that they're bringing a level of consistency to all clients. So you would need to disclose, have you ever worked with this particular client before? Have you ever worked with this particular law firm before? In addition to many of the types of other disclosures that would show either financial interest or social relation to one of the parties or attorneys. And that really addresses the degree to which somebody is saying, I can bring you a lot of repeat business. Well, now that kind of flips it, because now everybody is aware, because you have disclosed, of course, that you have worked with this particular party a number of times before. That puts it on the table, and they then, to your point, Professor Blondell, of self-determination, they then can decide whether you are or are not their kind of mediator for that case.
So let's talk a little bit about that. So, and that falls under, just to get you guys, if you want to be looking at a rule, that falls under, as Mark said, standard 3, conflicts of interest. It tends to dovetail with those Uniform Mediation Act states where I think there's a practice of doing more conflict disclosure, and we could talk, that's a Uniform Mediation Act presentation, not this one, as to why. But I will say that in Washington State, did my sound go? Am I still here? In Washington State, where I am originally, I had practiced, it was common in the commercial world, as well as I ran a labor management panel, to say exactly what Mark said he does for AAA. I've served, and you do this in a way that I think builds rapport rather than detracts from it. I regularly mediate with this client. I regularly mediate with this client. I don't think it impacts my ability to serve neutrally as anyone concerned. And I've never had anyone say no, never, based on my disclosures, and down to the number of times when it seemed important, other times when it was repeatedly, I didn't. So that's an interesting thing that we don't see in California. It's not part of the practice that you routinely see at the table. I do recommend in a court annex mediation context that you do that, though, particularly if you're working with the same adjuster over and over again in a particular pro bono context.
Underscoring the point, Professor Blondell, that you've made about not having people express a concern after you've made that disclosure, and in fact, looking good by having done so. One additional thing that I find in the marketplace is that oftentimes, once I have shared, or once I have answered a question, if somebody asks, have you ever worked with this particular attorney before, or this particular law firm before? Oftentimes, not only will they not have a concern, not only will they not appreciate the honesty and the transparency that I'm bringing as a neutral, but they'll also say, good, because we're looking for a mediator who they're going to listen to. We're looking for a mediator who has influence in the other room. So that, again, is an opportunity where you're able to address the ethical issue in a way that is also a positive for you in your practice.
Right. What's central about this particular one, the first 2 bullets, is it an ethical violation of yours when someone else says something? So they're trying to influence you. Does it suddenly become an ethical violation? No, I'm Teflon. I hear this stuff all the time. It slides right off me. So I'm not influenced by it if they say it. Now, the question then becomes, do I need to gently push back? Do I need to, disclose to the other side? I think the answer to that is no. But those are kind of the pressures you're feeling. Does it require me to do anything when they do that? Often the answer is no, right? It's just the stuff that people say. This last bullet, though, takes you into a world where it does influence you. Later, that attorney calls to check on your availability. You are, and we are just going to imagine the best for all of you, so booked up, you're booked out to March. and there's suddenly a cancellation. You promise the people on the cancellation list they would get the next available, and someone who had said, I'm going to bring you a ton of work, are you my kind of mediator, wants to sneak in. Do you let them sneak in? And that's a decision, let's say, that you're actually feeling the market pressure on. I'm curious, I don't know if anybody has been typing in the chat, but I'm curious if anybody has a thought about that. Anyone?
I hadn't seen that addressed in the chat, although I see somebody has just said absolutely not a concern. The only thing that I would say is that one way to insulate yourself somewhat is to flip the idea of the number of times that you've worked with a particular party or client into pointing to how much practice you're actually doing. So are you able to say, I mediated for that particular firm or that particular client 10 times last year, while then also saying, but I had over 200 mediations. So this is really a very small percentage of my overall practice. And my reputation for being a mediator of integrity and neutrality and honesty is a further way that you can highlight your ethics and say, again, if anyone thought that I was bought and paid for, I wouldn't be mediating as much as I am.
Phyllis has brought up, and my kind of last comment on this too is to think about this in terms of the impartiality rule. And thank you, Phyllis has kind of specifically given you some things to look at. I think it's actually implicated in several of the B's in the impartiality. It's always interesting when gift, favor, loan is all of those are can be widely interpreted. So you should neither give nor accept or an other item of value. And yet what we know is that people have prior relationships. We know people, it says you can do de minimis gifts, but we know that people invite one another out to their homes, to their parties, there is a community that can happen in the commercial world and that transcends. Not all the plaintiffs' counsel don't hang out together and all defense counsel don't hang out together. No, they hang out with mediators and they hang out with each other. And I don't think that we have sufficiently articulated the reality of commercial practice, at least in the code, but it's given us some no's. And so we need to move on, but certainly look at impartiality, because I think that's where we should end. It really addresses that in this particular one. Yeah.
Professor Blondell, one of the things that I left off of your bio is, of course, you are a member of the International Academy of Mediators, a very prestigious group for the tippy top of commercial mediators. And perhaps without mentioning names, you did share an example that was discussed among IAM regarding a gift. Would you like to take just a couple of seconds to throw that out there?
Well, one of the things that IAM does is they kind of pepper their listserv with these really great ethical questions. And so someone had at one point kind of said, okay, what if someone sent you a gift of something that you truly loved? Let's say you were a Dodgers fan and one of your repeated clients gave you a signed ball from this past year when the Dodgers won the World Series. And let's say, I'm making this up, as you can clearly see, I'm kind of veiling some of the facts here, but that it was worth $27,000, right? Would you experience that in the world of commercial mediators making $10,000 a day? Would you experience that as a de minimis gift? Or not? Would that be something that when that person came to your mediation room, would you now need to say, I know these people, I know them personally, actually we're friends. I don't think that gets in the way of me being able to mediate the case. But even the Dodgers ball up there on the top of my shelf was one given by him. I just want to make sure people are clear about, the field. So is that okay? Is that not okay? I think there is not a definitive answer on this one, although I might start seeing some in the chats, but I think many people feel that something of the value of $27,000, for example, would not be a de minimis gift. So I'm just going to read to you standard 2, impartiality B3. A mediator may accept or give de minimis gift or incidental items or services that are provided to facilitate a mediation or respect cultural norms, so long as such practices do not raise questions as to the mediator's actual or perceived neutrality, impartiality. So that's an interesting one, because if the other person says, no, it's fine, then, apparently it hasn't raised that question, but I think this one's a really interesting one. So good questions in here that are coming up. Okay, so let's move on. Let's skip scenario 2 just for time, Mark, and go to scenario 3. Does that make sense to you, or do you want to say a word about scenario 2?
Always helps to have more material than you need, and I'm here to tell you that anytime you have a chance to work with Professor Blondell, the time goes too quickly. She's that good. So the topic is a year in review. So one of the things that we had for scenario 3 on that slide was, what are some things that we're seeing in the current environment that are COVID related? So a few of them, we've talked about bankruptcies. This week, I had a case that did not settle on Monday. And on Wednesday night, I saw an article in the LA Times that the defendant had just declared bankruptcy, their parent company. So I immediately reached out to the parties to see, how is this going to impact? Are we looking at a stay? Are we dealing with insurance money? Are we not going to be seeing the inside of a courtroom, even though the judge on that particular case was really keeping people's feet to the fire? Are we not going to be seeing the inside of a courtroom now for a few years as this wends its way through the bankruptcy process? And wouldn't you know, after having sent out that email that evening, the very next morning, in very short order, the case settled. Still for a significant sum, but considerably less than plaintiff's last demand. That obviously, bankruptcies are not unique, but to the extent that it was a hotel, hotels and hospitality industry obviously are facing considerably more pressure in the current COVID lockdown environment, and that in that instance actually facilitated a settlement. I think that we're seeing people who are coming to mediation who are upset because of all of the other things that are going on in their lives. And one of the things that I often tell parties is that in mediation, they have control. Again, there's the self-determination that Professor Blondell was referring to. They have control. But when they're upset from a number of other things that are happening in their lives, the loss of a job, a loved one who's sick, children who are learning from home, etc., they can bring a lot of that upset into the mediation process. I had, for one of my mediations, a plaintiff who logged in very early, and as I was admitting her to her private breakout room online, she was apologizing to me, and she took a step back and was looking at the background of her room, which was empty other than the chair in which she was sitting, and she apologized to me, and I didn't understand why until she said that she had just have to sell all of her furniture in order to pay the rent. And how does that impact my neutrality as we're going forward? When I know that she is in those financial straits, how does that impact how it is that I'm going to be dealing with that party when I already know the tremendous financial strain that she is under, and I can see the upset that she is bringing to the mediation process? An issue that I'm certainly seeing is, I've had discussions with a number of plaintiffs' attorneys over the last few months that they would rather bring a case to arbitration sooner rather than later. Generally, plaintiffs' lawyers prefer to have juries try their cases, but a lot of plaintiffs' attorneys who've been practicing for a while are saying that in the wake of the 2008 Great Recession, jury verdicts were coming in a lot lower than they expected, that because of the overarching financial environment, that juries were being a little bit stingier and a little bit less generous with plaintiffs' awards. Lastly, an issue that's coming in for purposes of mediation is, I was able to settle a case where defense counsel sends around her standard settlement agreement draft for everybody to take a look at and approve, and plaintiff's counsel was threatening to scuttle the settlement because the quote-unquote standard settlement agreement language included a clause for force majeure. That force majeure clause was saying essentially that the defendant's performance under the settlement agreement could be excused if there were acts of God, if there were riots, if there were floods, if there were pandemics, etc. And plaintiff's counsel correctly pointed out that at that time we had riots, we had a pandemic, and arguably there were acts of God. So what were we going to be able to achieve with the settlement if the settlement agreement that's memorializing it is saying essentially the defendant's performance is excused for 3 different reasons? So this is some of what it is that I'm seeing in my day-to-day in the COVID environment, and that then brings us to what are the ethical implications that raises. And Stephanie, I see that you've already put those on the screen, so let me hand back to you.
I put some of them. One of the things I just want to point out is that here is where I think, codes are incredibly helpful and they're important, but also the ethical processes that influence us are a factor as well. So I'll just say that, have you noticed that the first COVID case, the first case you got where someone had lost a family member to COVID or had been deeply impacted, felt different than the second case? For me, it did. I'll just say for me, it did. I'll speak for myself. And so that internal bias of us seeing things reflected in the media or in our homes, perhaps, but many of us, I think, have seen it reflected in a big way. It has a symbol for us. It means something. And then we see a case, we might behave differently than the second, third, fourth, fifth time we've seen this case. So I think that that's important in terms of the emotional issues that are coming to the table right now, to just be aware of your own internal biases or what they mean for you. Specifically, I'm talking about politically, as well as other ways. One of the things that I have seen come up that I'll just discuss is counsel missing legal issues, because there are some new issues of the day. And I think it puts a little pressure on folks, especially those folks that I'm talking to right now are non-lawyer mediators, in terms of UPL, or many of you may know, and this is another presentation as well, that if you're a California attorney, you're not going to be written up as the unlawful practice of law. But if you're not, you could be, or if you're from another state, licensed in another state. If you're in California, it would come under the business code, and it's pretty rare that would kind of surface. But what if, this is something that I've seen recently, what if you're a mediator routinely addressing facts underlying commercial leases, because that's kind of what's coming to the table right now, and you had some bizarre little thing come up in your case, like the landlord had a flood. It was discovered during the case that their coverage was much lower because they were unoccupied or had less than or only one tenant or something like that. And because of that, the coverage reduces slowly. Well, a flood doesn't discriminate whether or not you have a lot of people or not, right? If you have one person or you have 50, it still does the same amount of damage. It turns into an issue. And then you go to the next case and you see the potential for another misunderstanding there. Do you offer that information? And, this is once again a contextual question, whether or not there are attorneys at the table, if they're not attorneys at the table, but how does it impact, the attorney's role to be the advocates and your role to be the mediator? Mark, do you have any thoughts about that, or do you want me to continue? Or maybe people can put it in the chat if they have some thoughts about whether or not they would, let's just make it a clear question. Would you raise it in subsequent cases, that issue as a mediator? And thank you for those brave folks who are bringing it up. Not directly. Thank you, Jamie. Anyone else have a thought? Interesting. I will say that for me personally, Jamie says, yes, there are ways to do it though. So for me personally, I do think that's one area where it's a slippery slope, and it's so tempting to want to, we entered this field because we're problem solvers. So want to prevent a problem in the future, or to want to build rapport with our, insight into cases and what we've been seeing. I will tell you, I think this is routinely done in the commercial context between California lawyers, and I would be personally, I would be cautious. This is an area where I would if the person is represented, well, if the person is represented or not. I might ask some questions about the contract. Are there other aspects of the contract we're concerned about? Have you reviewed coverage? You know, as Jamie was talking about, other ways around it. And if they don't take the bait, it's not like those questions would then lead me to, you know, go further than that. Just leave it alone. And with the being rest assured that every case settles based on the factors that are important to those parties, and that self-determination matters. Are there any other comments on that? I mean, we have tremendous minds in here, including Phyllis, who teaches mediation ethics at USC and is a former SCMA president as well, giving our props to our SCMA presidents, as well as others. Anyone else?
I'm wondering, Professor Blondell, given the important next topic, if maybe this would be something to include in Q&A after.
Oh, it's 12:56. We're moving on. Thank you. Okay, so moving on. This is just one thing that I want to make sure to raise, and that is addressing kind of marketplace bias. This has been a year where I think all of us, if you have not felt your role as neutral challenged in some way, then my guess is that you're not living on the same planet that I am. I think many mediators are talking about it. Ken Cloak, for a while, had this amazing article he wrote up on his LinkedIn. And I think he's going to have a piece that's going to be published very soon about kind of internal neutrality and how you bring who you are to a mediation. So if you're a mediator who believes in fairness, equity, and inclusion, how you bring that persona to the mediation and not get confused about what impartiality means and what impartiality doesn't mean. I do think there's a place for us to currently be talking about this in more detail. In the rules, we see diversity being addressed in quality of process, and we see it being addressed in advancement of a mediation practice. In the ODR article by Leah Wing that I put up for you, she talks about the value of principle-based ethics as opposed to necessarily rules, which calls on kind of a higher ethical pull, which means that there's, you know, unfortunately, there's probably some more room for being subjective in that, but it allows the parties to provide guidance to the infinite variations and come back to a principle in order to make the decision, rather than trying to kind of do, does this fit into the rule or not? Can I sneak out of this? And I think that it prevents this, you know, kind of mechanistic box ticking moment that can happen with overly drawn out or overly articulated rules. And, you know, we don't want these legalistic loopholes. We want us to vibrantly have a conversation with our community. So for example, vibrantly within SCMA, have a conversation about not only how diversity and equity impacts us as an organization, and this is just, you know, planting a seed for maybe some sort of conversation later, or a vision statement or something to help the advancement of mediation, but also how do we do that in our practice? How do we bring the persona of being a social justice mediator into your practice if you want to? And I've heard a lot of really brilliant people addressing and debating this issue in the last year, and I'm hoping that we can bring that to all of the brilliant minds in here as well. Mark, I don't know if you have a thought about it, because I'm seeing now our time was such that I just kind of riffed there a little bit without pausing.
Incredibly important issue, certainly something that is incredibly topical right now in the wake of all of the discussions and protests over the course of the last year over diversity, equity, and inclusion, over police shootings, over structural and systemic racism. So definitely there is going to be more programming on this. Nothing that we have to announce just yet, but this is definitely something that SCMA is wanting to tackle in the year ahead, in much the same way that society is grappling with it as well. Before I wrap up, Professor Blondell, anything else that you were wishing to add?
There was one great question in the chat that I just wanted to throw out there that I'm going to give my quick response to. Mark, you may have one as well. Someone asked, if one party wants to meet in caucus and the other party wants to meet in joint session, is that something that needs to be mediated? And they say it in confidence. Do you have an obligation to tell the other side? I will tell you in general, I tell the parties at the beginning of my mediations that process choices are not confidential, that content is confidential. Now, if a party articulated to me, I want to meet this way or that way, but I don't want them to know that, and they really kind of highlighted it and, put a candle on top and, did the whole thing, then I would do it out of a sense of respect to the parties, and self-determination. But generally, I don't promise. Process choices are part of our confidentiality. That's just what I tell the parties in the beginning. So I don't see that as a huge deal. What the parties are willing to do is what the parties are willing to do. I don't know, Mark, if this has come up in your practice or not.
I had a mediation where one of the parties actually had a restraining order against the other. And even in the current COVID work from home environment, they nevertheless insisted the mediation still had to take place in person. Thankfully, my facility allows for different floors. So I was able to literally put one floor for one party, one floor for the other. But yeah, to what extent are you going to be abiding party preferences? To what extent are you going to be honoring party self-determination? And as we are all dealing with over the last year, to what extent are you simply needing to make sure that you are, as a professional and also potentially as a business owner, making sure that you are hewing to legal requirements when it comes to party safety and health?
Yeah.
Thank you, Professor Blondell, for a fantastic presentation. Obviously, if we were doing this in person, you'd be getting thunderous applause right now, but you can imagine it. With that, thank you again. Thank you, SCMA, for putting on this excellent program. I wanted to point out another few programs that are coming up very briefly for each of you. First off, and this is going to be this next week, January 27th at noon, our Attorney Outreach Committee, and you're seeing some details right there on screen. Our Attorney Outreach Committee is going to be offering Online Mediation 2.1, making the best of online mediation. And our presenters for that will be former SCMA President Jan Shaw, we thank her, and also Gretchen Nelson. Thereafter, we've got our 4th annual Family Mediation Institute, which will be taking place both on February 19 and February 20. We've got information on screen for that as well. Again, that's going to be with the theme of exploring new frontiers in family mediation. Much more programming that is going to be coming out in the weeks ahead. We're really wanting to offer as many opportunities as we can in the work from home environment for people to be engaged with SCMA, for people to learn, for people to get educational credits, and to challenge themselves. So I thank every single one of you for that. Also, by way of a heads up, you will be receiving shortly an online certificate of attendance for MCLE purposes. You'll be receiving an online survey so that you can give feedback for Professor Blondell and myself. And then lastly, as our director mentioned, you'll be receiving a certificate so you can get credit for this presentation should you be renewing your MC3 certification or looking to apply for MC3 certification in the first place. With that, again, huge thanks to Professor Blondell and to everyone who was responsible for putting this program together. And thanks to each of you. Be well.